Hari ini kita dapat keputusan Mahkamah Tinggi berkenaan dengan kes sivil Datuk Seri Najib yang melibatkan SRC, iaitu claim, kalau tuan-tuan dan puan-puan masih lagi ingat, claim berkenaan dengan 4 bilion ringgit, iaitu duit daripada pinjaman PUAP, dan 120 million US yang bersamaan lebih kurang 40 million ringgit. Yang bersamaan dengan 120 kali 4. That will be lebih kurang 800, ya. Atau 700 lebih million Malaysian. Dua claim je, ya. Jadi sebagai permulaan ataupun latar belakang, pada permulaannya plaintiff iaitu SRC di antara yang lain menjadi sebagai plaintiff dan telah pun sue Datuk Seri Najib sebagai defendant pertama, dan kesemua directors ataupun pengarah-pengarah syarikat SRC semuanya. Kemudian satu perubahan telah berlaku di mana SRC telah pun diarahkan untuk menarik balik nama-nama kebanyakan pengarah-pengarah SRC keluar daripada tuntutan yang dikemukakan. Hanya tertinggal ataupun ditinggalkan Datuk Seri Najib dengan Nik Faizal. 2 orang saja. Jadi Datuk Seri Najib telah ambil keputusan sebab Nik Faizal bukan dalam negeri, dia telah lari ke tempat lain. Datuk Seri Najib telah ambil keputusan oleh sebab nama-nama yang lain tu telah pun dikeluarkan, dia mengambil tindakan third party claim. Iaitu dia kata kalau dia didapati salah dalam kes SRC Civil ini, apa-apa peruntukan wang yang dikenakan terhadap dia sebagai damages haruslah juga diambil daripada third party ataupun contribution daripada third party, iaitu pengarah-pengarah yang lain yang nama-nama mereka telah dikeluarkan, termasuk Nik Faizal. Okey? Jadi itu dia punya defense dan juga dia punya third party claim. Okay. Hari ini mahkamah membuat keputusan dua perkara isu isu-isu yang agak ditimbulkan adalah hanya dua secara dasar. Pertamanya dalam kes pertama di antara SRC dengan Datuk Seri Najib, mahkamah telah membuat keputusan bahawa Datuk Seri Najib adalah pihak yang bersalah, bukan dari segi jenayah, ini dari segi civil, iaitu untuk membayar kepada SRC 1.1 bilion US dollar, yang itu satu, dan 120 million US perkara yang kedua. Jadi dengan melihat itu secara kasar pun kita dah nampak bahawa 120 million itu memanglah satu kuantum yang sudah pun termasuk dalam 1.1. Jadi kita juga heran macam mana keputusan dibuat, di mana dua ni diberikan satu penghakiman yang berasingan. Okay, so it's a bit wrong. Dan bila kita kaji kedua iaitu berkenaan dengan third party claim, sungguh pun pada permulaannya hakim bersetuju dengan kita bahawa third party claim yang kita buat, terutamanya kepada Datuk Subuh, tidak terpengaruh dengan kes SRC jenayah ataupun kes yang ada kaitan, tetapi beliau mengatakan Datuk Seri Najib berhak membuat tuntutan third party sebab dia tidak kena-mengena dengan isu-isu yang lampau. Ya, tetapi didapati bahawa third party claim oleh Datuk Seri Najib juga tidak berjaya atas sebab-sebab kononnya Datuk Seri Najib tidak dapat menunjukkan bahawa third party tersebut, iaitu pengarah-pengarah third party, keputusan mereka tidak secara substantifnya melibatkan kerugian kepada SRC. Okay. Dari segi detail ataupun perincian keputusan-keputusan ini, kami rasa tidak puas hati langsung. Kami akan membuat satu rayuan. We will appeal. By this, within 14 days we will appeal. Or rather, within this week we will appeal, and within 14 days we will make the application for a permanent stay until the decision is made at the appeal in the Court of Appeal. All right. Now, a few things we want to mention to you is this: the few unsatisfactory features of this trial. First, you remember we said very clearly that there is no such thing as a top-down approach, where the shareholder make a decision and then the board of directors follow. There is no such thing, because that's not the law. The law is always the people who makes the biggest, the main decision are the board of directors at the board meeting. The judge doesn't seem to pay attention to this fact. This is a fact that we raise as a defense. So, quite clearly, this was not addressed. Number two, the learned judge also said that Datuk Sri Najib was a shadow director. Yeah. Now, he seems to have followed the logic, or rather the decision in the SRC criminal, although he said he's not bound by it, but he seemed to have followed. But I want to say one sentence. There is no evidence at all that was tendered here where Datuk Sri Najib was said to have given direction, verbal or otherwise, that the board must follow this way or that way. What they produced was only shareholders' resolution. But shareholders' resolution, as you know, in our case and also in 1MDB and also SRC criminal, the shareholders' resolution is dated the same date as that of the board of directors resolution. So this is an impossibility. How can two bodies separately dated their resolution on the same day? So which one take place? They have never answered, and the judge did not deal with this point. It's a very important point. Okay, so to conclude that he is a shadow director, there must be a lot more evidence that he interfered and he directed the board of directors. Not a single member of the board of directors have testified, or any other witness have testified, that Datuk Sri Najib directed the board and he engaged the board and he virtually forced the board to adopt his decision. Sorry. Yeah. And then we have got a federal court resolution, federal court decision that says that shareholders' resolution does not bind the board of directors. So today's decision, the most unsatisfactory feature is this. The judge seems to recognize that the board of directors can collapse and not make any decision, especially intelligent decision, if there is a shareholder like Datuk Sri Najib or the Minister of Finance that make a decision by way of shareholder resolution, the board of directors can just not perform their function and they will escape liability. Now that is squarely against the Companies Act. Companies Act say board of directors have got fiduciary duty, and their duty is to the company, not to the shareholders. So if people cannot do their duty, they should just resign. They cannot say, I am so pressured by Datuk Sri Najib because he's the Prime Minister, he is the Minister of Finance, and he's a shareholder, therefore we have to follow. When they know following him blindly is a crime, is also a breach of fiduciary duty. But this was not addressed by the judge. These are some of the things. There are many other things that I want to speak about. Like for instance, the entire case is based on hearsay document. Yeah, and the judge accepted all the hearsay documents and provided the excuse that while they can be hearsay, but they are corroborated. The judge said they are corroborated. we think that is a wrong way to approach it, because first of all you have to decide, is it admissible? Once it is admissible, then only you decide on the question of corroboration. Without it, you can't do that.
Mr. Can we ask, has the quad loan, the 4 billion, has it been paid by other parties or in other arrangements?
Okay. I am sure, because this is not in evidence,
Right.
I'm sure the part payment of this loan has taken place and maybe is taking place. But what we are most upset about is all the 4 billion, Datuk Sri Najib never benefited, not 1 cent. Because remember the judge said there is element of passing through his account, nothing to do with the 4 billion. But it has got to do with the 120 million US. But even that, the judge said Datuk Sri Najib's account was used as a pass-through. Pass-through means he went into his account and went out, back into the same pool. So where is the benefit?
But Judge,
There is no benefit to himself through his account. So how could he be dishonest, or there is element of dishonesty in him keeping the money, because he never kept the money.
the judge kept on repeating abuse of power so many times.
Yes.
And then the other thing, he said that Datuk Sri Najib was used SRC for his own personal gains.
Ah.
And I think he said one more thing, I can't remember what. But you know, this is like Datuk Sri Najib is the only one that's running SRC everywhere during a time when he was Prime Minister. And that's something not right there. It's very difficult for us to comprehend the
Okay,
kind of...
all right. You know, SRC was formed not by Datuk Sri Najib. Datuk Sri Najib may consent to it because SRC was initially under 1MDB. Okay? Now, SRC was formed in order to be a small version of Petronas, but not dealing with oil and gas, but dealing with other kind of energy products. It was a strategic company. That's why it is called SRC. SRC means Strategic Resources Corporation. It was meant to benefit Malaysia. All right? Unfortunately, the management with one outsider called Jolo, and the failure and negligence of the board of directors, Datuk Sri Najib did not receive the benefit of good advice. And the 4 billion from Kuok was misused, but never for the benefit of Datuk Sri Najib. The 4 billion has got nothing to do with money that went into his account. The 120 US that went into his account was a pass-through. So where is the abuse of power?